So I'm Eric Ball, litigation partner here at Fenwick and West, with my colleague Kimberly Culp. We focus a lot on the copyright issues and trademark issues. Also big on the advertising and FTC things that Kimberly is a total expert in. That we're going to talk a little bit about here today. But first, go ahead, Kim.
So we broke our presentation up into 3 buckets here. We wanted to talk about some of the cases. We've heard a lot of interesting things that people are doing with AI, and some of the questions are, well, what do I own? Like, what's like, am I going to get in trouble for this? And so we wanted to give you the lay of the litigation land first. And then there's obviously been very recent U.S. Copyright Office guidance. We're going to talk about that. But where we want to sit for most of the conversation, and we welcome questions, is sort of like, what does this really mean? If you're a content creator, if you're a platform developer, how do we pull it all together? And what's the advice that Eric and I and others in the firm are giving as we sort of think through, do you own this? Can you rep and warrant this, et cetera, et cetera. So let's get into some of the cases real quick. So the first one really gets at the question of, can you get a copyright in something that, is entirely owned by the AI, created by the AI? The answer is no right now, although, there is a pending case that's testing the question. So an individual, Thaler, his AI created this piece of art. He tried to register the copyright in the Copyright Office. The Copyright Office said no. He said no, but really please. And they still said no, but no. So he sued them in the District of DC, and there's a pending motion for summary judgment that's been fully briefed on the question of, do you really need, any component of human authorship? And it should surprise no one. The Copyright Office's position is still, yes, you do. No, the AI cannot be the author. I don't think anyone thinks that the outcome of the litigation is to be any different than what has, come before. I think the interesting question would be, would the litigation be different if it wasn't the Copyright Office? The Copyright Office is obviously going to get a lot of deferential standards in terms of that motion for summary judgment. So, where I'm at is I expect him to lose, and I expect the answer to remain the same, but it will be an interesting question if, the litigation gets teed up in a different way and, someone tries to make a run at human authorship again.
I'd add, I think it'd be interesting, maybe a different case if it wasn't Thayer that was pushing it, who's a AI maximalist, and he's also, I think, his petition for cert in the Supreme Court was just denied this week, and on saying, can an AI patent something? And so, he is not he's a provocateur, he's pushing the boundaries, but maybe not the best plaintiff to bring this case.
So the next one, not litigation, but seems to fit nicely in here, which is, we have a comic book that is created using AI. And if we can actually, so we have some screenshots here of just the comic book itself. And if we go to the next page, there's a copyright registration that was given, and then there was some, notice provided that actually the AI was involved. And so, an amendment to what ends up getting copyrighted. The text of the comic book written by the individual, the Copyright Office says yes. The selection and the arrangement of the pictures and the words and all of that, yes. The images, which were created by the AI, no, because the individual, the human, didn't participate in the creation of the images. So again, the Copyright Office doubling down on you have to have some human participation to get a copyright.
And to put this in practical terms, what I really like is 2 things. One, on the selection and arrangement, think of that about the telephone book. The telephone book is a bunch of facts, but sometimes the selection and arrangement where you put the ads, you might be able to get a copyright of that arrangement in the telephone book. And then on the images here, think of it as a Google search of an image. You put in a Google search for Eric Ball or for elephant, and you don't know what you're going to get back. You don't have any control over those pictures that you get back. You can get a picture from me from, 1982, or you get a picture from 2005. You don't know what you're going to get back. You didn't have any control over that. You can get a pink elephant or Dumbo or some other kind of gray elephant. Don't know what you're going to get back. And that's why she didn't have control over that output, and it's not protectable.
And so the next two cases, we have the same defendant, different plaintiffs teeing the issues up in different ways. There are copyright claims in both the Anderson versus Stability AI case, which is up on the slide. Now we'll take a look at the Getty versus Stability AI in a moment. So as I say, different plaintiffs, same defendant. Both cases too also have a variety of other non-copyright causes of action. This one includes a right of publicity cause of action. Essentially, it's in the style of my art. And so this series of cases is really looking at the question of if you're ingesting the data, the input. There's certainly an output issue as well. And then there's the right of publicity issues that are related to the output that's being litigated from a liability perspective. What's the liability of the platform for sucking in all of this data? And in this case, you have the art from the artist on the left and the output on the right on the slide. What's the liability for the platform? Very early stage in the case, motion to dismiss is pending. So let's go to the next one unless you have comments there. You want to talk about Getty?
Yeah. Oh, am I talking about Getty or you?
So this is the other Getty, and then we'll sort of bounce back and forth for a minute. So Getty's case, the add-on claims are trademark claims, right? So you've got the right of publicity in Anderson, you've got the trademark claims in Getty, and you can see in these, the Getty logo on the images. I'm curious if you can even identify, one of these is a real Getty image, if you can identify which one it is. Yeah. So the second one is but you got to look, it's not immediately obvious which one is Getty and which ones are the AI. And, you can get a sense of that's part of Getty's complaint is, the AI is spitting out our logo on on the images. And so we aren't at the motion to dismiss stage yet for this one. And, candidly, I like, Getty's case quite a bit for Getty on, some of these claims are going to survive whatever motion to dismiss comes. That's my prediction here. And we're going to get some answers around liability for platforms from this pair of cases. I think this one in particular.
And we'll talk about fair use a little bit in a second, but one of the reasons why I like Getty's case a little bit better here too is the going to the logo or copyright management information claim that they have here. And if they're tweaking that copyright management information, which is where they're saying Getty images, copyright, and that being kind of altered, manipulated, blurred, those are all of that can go to that copyright management information claim, which is a harder one to do on a fair use saying, oh, I made it Eddie images or Getty images, and that could come up with an AI where it's tweaking it and you no longer have that Getty images copyright management information on there. So that alone, I expect will get past the motion to dismiss and something that's going to be harder to defend on fair use or anything else.
So, and these are, we've already alluded to it, but these are some of the other claims that are being alleged in Getty. If we can go to the next slide. So fair use, right? The prediction is these cases are really going to come down to the fair use question. Like once we get past the pleadings, where the rubber's going to hit the road, and it'll be an interesting question, is how the fair use question plays out. It's not been teed up yet, but in terms of watching cases from a platform perspective, from the input output, these are the pair of cases to watch. Certainly for what's been pled and what survives, but really for the fair use question.
And, talking to a colleague earlier this morning, a very smart gentleman, Jed Wakefield, in the audience here, he raised the good question. If you're an art student and you go to a museum or you've been studying art and, you're thinking about, okay, I've studied 100 paintings from Picasso and Monet, and I want to do a kind of a mashup of all those and paint something of my own. And you've now created your own work, even though you've studied all those, or you've got a book of them, and you've created something new. That would be an okay new work that you've created on your own. But if you have a database that does that same thing, that has a collection of a bunch of old works, why isn't that also okay? Let's take a put the aside that there's no copyright still in, say, an old Monet, but that's still something that's going to have to be decided here. Just because it's a database instead of an art student, is that fair use? Is that something that you can use?
Yeah, just because I like to play the games of hypotheticals, right? You could see someone who's would otherwise get an image from Getty. Yeah, they're going to do an article about Andy Warhol and Campbell's Soup, putting aside copyright issues, and you put into the input Campbell's Soup in style of Andy Warhol. Like, what's your output going to be? It's probably going to look almost identically like an Andy Warhol, because that's probably how the system has been trained for that, And so from a fair use question, it's like, well, I would have paid for the image from Getty, but I can just put it into a system and get the same image, the Getty image. There are going to be fact patterns that are going to, raise interesting questions for fair use and challenging questions for fair use.
Now on to the Copyright Office's current guidance, and next slide I highlighted, but it says this is all subject to change. The Copyright Office is coming out with new guidance. This came out, what we're in April, so about 4 or 5 weeks ago, and I think a lot is still moving. I mean, we just got an announcement from the FTC yesterday on AI issues and how they're looking to enforce. They had another announcement a couple weeks ago as well. So government is interested in this, and things are changing as they're all trying to get their arms around it as well. But just to start kind of where we started here is it's copyright protection only for works that are the product of human creativity. There has to be that human mastermind behind it. They're still though going to assess this case by case. We saw the Zara comic where they said, no, that doesn't work. But that doesn't mean that anything with AI doesn't have copyright protection. You can still have copyright protection. You need to assess it case by case. You need to hire great lawyers to assess it and understand, is this something that's copyrightable? What part of that is copyrightable? You've got derivative works, which is a lot of what's happening in these AI issues as well. Some copyright protection, but again, more likely to be thinner. Some important kind of do's and don'ts here, again, is that you have to disclose if you're using AI in your copyright application. The human authorship must be predominant, is what they're saying. So it's not even like, yes, I had a small little piece of it. It must be predominant. You should highlight the human contributions in your derivative works. And, AI is not an author. It is a tool. It is a PDF maker. It is Microsoft Word. Do not consider it the co-author of your copyrighted work. If you do and you're there, you're going to be slammed by the Copyright Office and it's going to get rejected. Why this matters for the Copyright Office, why we care, especially in the US, is in order to sue in the US, and it's been reaffirmed by the Supreme Court a couple of years ago, you need to have a copyright registration to sue in the US to enforce your rights in court. You can enforce your rights maybe through some takedowns or demand letter or something else before you have a copyright registration, but you need a copyright registration to enforce your rights in the US in court. It's also important, though, that the Copyright Office is helping guide you on what is actually copyrightable, what you can have rights around. And that's that second point, the Swirsky case that we highlight here.
Just real quick before we hit the takeaways, I want to put a pin in something that Eric mentioned, which is and we've already alluded to the statement that came out earlier this week from the EEOC and the FTC. Eric had alluded to the FTC's earlier statement from a couple weeks ago, where they, make the point that how you're advertising your AI, if you're saying, powered by AI, but it's not really, or if you're using AI in a way that is a dark pattern, or if you are creating an AI that can be used for that purpose and then selling it, you should really be thinking about whether you should be selling it, because you might have liability for doing that. So there are these copyright liability issues, but we've already already seen non-copyright liability claims being brought into, the two stability cases. We've seen that the government at different levels is paying attention to this. And so the point is, yes, this is a copyright panel, but really want you to be thinking about your AI, your use of it from a holistic perspective, because the government at different levels is doing that exact thing.
And especially as we just saw from VJ and Tracy on the terms of service, what are you, and we'll have a couple of takeaways here, but what are you telling consumers you're offering? What are consumers walking away thinking that you're offering?
So we've broken the takeaways up into, for content creators and then for platforms. So on the content creator side, it's incredibly important to, document and track and be certain of the human element of authorship. What are people doing? What are they drawing? What did they draw? Show me what they drew. Keep records of that. You want to be able to substantiate that if there's ever any question about human authorship. So don't just say, to Eric's earlier point, oh, well, a human did this one thing over here, and you're going to rely on one person who's maybe going to have some vague recollection to that thing. If you know that the AI is being used as your PDF, your Microsoft Word, be sure to know what the human piece is doing, because there is this question right now. Well, how much, human activity?
And I'd almost see that as if you're used to it in the patent world, you have the inventor notebook. And so you're tracing along the way, what was the human in doing? What was their human involvement in their input, in the design, in the, as we say in the next one, the curation as the output comes. Do they say, no, I don't like that, I want to refine that, I'm going to change, some of that information? I mean, in Zara, they said it wasn't enough, where they filled in the lips a little bit. They changed made the lips actually look like lips instead of sometimes what we see in some of these images where the face or the hand is kind of, not exact. This is what, those are the kind of information to really write down and make sure that you're tracking.
Yeah, not to just pile on top of it, but it is worth really thinking about documentation. On the advertising side of things, when we talk about substantiation, we're looking for show me the piece of evidence that lines up with the claim that you're making, right? Show me the piece of evidence that you're making that you did this particular activity. And so, however the organization thinks about documenting that, it's different than just well, we have this piece of art. Can we go get a copyright registration? It's not that same process. It is more akin to other processes that exist within the business in terms of documenting activity.
And we've gone through some of these already, but disclosing the AI involvement to the Copyright Office, don't identify the AI as an author, do exclude AI generated content in the limitation of claim is an important one in your application. And, obviously keep up to date with the regulations and the Copyright Office guidance, because all of this is subject to change. Separate from these do's and don'ts, I mean, this is all moving so fast. And I've seen a lot of kind of criticism in some of the space of the discrimination that's coming out of some of these AI outputs. And, there was one the other day where it was, everyone was assuming that the paralegal was a woman instead of when it's a question. And it even asked, the person even asked the AI, well, why are you thinking that the paralegal is a woman? And they said, well, because men can't get pregnant. And you said that the paralegal was pregnant. And it's just, there is discrimination that we need to be aware of and be mindful of. And so even if you are that content creator and something's coming out of it, you need to be mindful of, are you reinforcing some of that discrimination output that you don't want to be involved in? That's A. And then, B, on the flip side for content creators, I saw Grimes, the musician, just tweet the other day that unlike you might have heard about The Weeknd and Drake, how there was a mashup of them doing a song. Grimes has said, you know what? I love this. If anyone wants to use my voice and my image to create some AI related song and split the royalties with me 50-50, let's go for it. And she's, I haven't investigated her situation, but she said she's in a unique situation because she doesn't have any label. She's not bound to anybody. So she can go out there and just say, yeah, go use my voice, go use my songs, and we'll split this 50-50. My question is then who, is any of that copyrightable? Who owns that copyright? What's the bounds of that license? Can someone else then take that and not split it 50-50 with her because it's no longer copyrightable and just copy it and just play that? I mean, so there's going to be a lot of open issues around this, and there's going to be people like Grimes who she said, I haven't got it somewhere in here, but said, basically I want to burn down copyright law altogether. Summarizing, and there's going to be, open issues like that, that we're going to face and see.
I guess I'd add to, it's, if you're working with a creator, let's not get too excited and hyper technical about our AI issues. Let's not forget about just like basic copyright law either, right? So if I need a human, so I'm going to have the AI, Campbell's soup, again, putting aside all of the issues, I'm going to have the AI spit out the Campbell's soup, but I'll fill in the colors. And here's my, example, and it ends up being a copy, but yay, I've solved for the human who did the coloring. You've literally copied an image that's right there. Let's just not forget sort of our basic principles. These are in addition to, not in lieu of, right? So you can't copy in some other way. I had the tool and I had the human and I've done the things, and therefore you've said it's copyrightable. Well, you might have still infringed someone's copyright by the means in which you created it. So let's just not get so far into the weeds that we forget about our first principles.
You want to start this one off?
You can start this one off.
All right. And then here's the key takeaways for the AI platform developers themselves. One, establish those clear agreements on ownership, authorship of rights, and authorship and rights in the AI generated work. So that's what BJ Wood and Tracy were saying a second ago. And I've definitely had this dispute. Kim and I have both had this dispute, and I'll let her speak on hers, but on opposite sides of it. I've had it where someone had used an AI generated image and then sold it to a client and not telling them that it was an AI generated image. And that image has been subject to a license from the AI platform, just like many other things. And they're saying, yeah, we're giving you all the rights. And all of a sudden, like, companies like, wait, what rights? And so those are issues that you got to be clear, and everybody's got to walk away understanding exactly what they're owning. And you really need to dig in, especially if you think that an image is AI generated. Am I getting what I expect to be getting from that content creator?
Yeah, and the opposite side of it, working with one of VJ's clients, it's like, are you representing that you're giving something that you actually can give? Are you saying I have copyrights when in the back of your mind you're like, I don't really know that I have any copyrights? Well, then you probably shouldn't be repping and warranty that you actually have them. And so, like, having an understanding of what you have so that you can honestly and accurately put in your contract what it is you're giving to the other party, again, so there's an understanding and you're not finding yourself in a breach of contract situation.
And then the next one is, again, this is important also from the FTC's perspective, is clearly communicating the capabilities and limitations of your AI platform, informing the users about what's the AI's role in generating that content. Some of that is just telling them where the content's coming from. What are the databases that they're using? That can be a helpful source of information for that user.
Yeah, I immediately go to more of the consumer protection issues than the copyright issues with this one here, which is, your advertising claims need to be honest. They need to be not misleading. That includes with data. If you're communicating with the AI, are you honestly and accurately representing what's going to happen with a person's data? But you really, again, having that understanding of what's happening and then making sure that representation out to the public matches what's happening is incredibly important.
And the next sub bullet with, I noticed this typo earlier today with the open circle, that was intentional so that anybody copies this, I can see if they've copied our typo. But no, we've already seen, resources and guidance in fair play in gaming and how to reduce bullying in gaming. There might be opportunity here for guidance and resources on proper use of AI and how you can use AI in a way that isn't discriminatory and doesn't reinforce bad inputs meaning bad outputs. And so that is something that I've been looking into and seeing how much we're going to be able to kind of reinforce and provide some guidance around proper use of AI.
Well, I think it's a good reminder too that consumers are familiar with AI, even if they don't realize they are familiar with AI. AI helps make games fun for sure, right? I mean, it's like if you play games, you have interacted with AI if you've interacted with a non-player character. I mean, on some level, with games these days, you are. And consumers don't need to be told what's powering a non-player character or what's powering sort of like chat features to make sure that there is an abusive and harassing language in the chat, or any number of those sort of protections that exist in games. But there are, California has a law around making sure that you're disclosing if you can't misrepresent that you're talking to a person when you're really talking to a bot, right? And so it's like, when does it really matter to the consumer? Like, someone doesn't need to know that a non-player character, how it's happening. But, if you think you're talking to a real person who's really going to serve you and it's a computer, that's sort of the situation where consumers can be tricked. And so making sure that you're not sort of taking the consumer for granted there.
And skipping over the third-party content one, which we've addressed a little bit, but going to Kim's point there, keeping up to date on those regulations and making sure that you are addressing not just copyright issues, but FTC advertising issues, that you're addressing dark pattern issues that the FTC is definitely focused on right now, that we're addressing trademark infringement, dilution issues. Is that maybe they had Getty Images exactly right on the image, but they put it on an offensive image, and now we've got a dilution claim. So you just got to be very focused on, it's not just a one size fits all. Yes, copyright doesn't exist. There's no copyright here because it's AI generated. You might have other claims and other issues that can create problems.
Yeah, and sort of looking back to Getty, it's not a perfect solution. It's not a solution that's going to work for everyone. But, if you can license the data that you're ingesting into the AI, or if you own the data that you're ingesting into the AI, you're a game developer and you're using AI to generate your non-player character and your scenery, and like you own all of that. Those are different risks than what we're seeing in the Getty situation. So if your client's in a position, if you're in a position to ensure that, what you're training the AI on is data that you own, data that you have rights to, those are different risks than what we're seeing in the Getty situation. So clear agreements, but like those are agreements that can help protect the business. We promised Kelly we would get us back on track.
And we're very close.
And we are doing that. If you have questions, we have time for questions, but we also promised we'd get us back on track.
Looks like Armin. Yeah.
I have one question about the duty to disclose. How broad is it? Because there are AI tools that are outside of just generative AI that have been around quite a while, are integrated in photo editing and video editing packages like magic erasers and things like that. Do all those uses have to be documented and disclosed under this guidance, or is it not clear?
And you should repeat the question.
Yeah, so the question from the audience was, how broad is the duty to disclose? As Kim was saying, earlier, there's a lot of AIs that we all use, and the question is it an AI or is it just a tool to help something? Versus the AIs that everyone's talking about now, which is a massive database, and you put something in, or you ask the database to create a certain image, and it spits something out to you. The answer, I don't know, and I haven't dug that deep into that. VJ's got an answer. I mean, I was going to give a speculative, but VJ, well, I was going to say, no, you don't need to disclose Magic Eraser. And because I thought there was something that it says, we're not talking about the PDF fixer or anything else. It's much more that. VJ, what's the more detailed answer?
I think to the extent, Section 5 of the FTC Act has been applied. So to the extent it's a misrepresentation or something the consumer would want to know before it purchases, for example, or when you think about marketing, there's a lot of regulations around native advertising, and the thing that always comes back out to me is they call it deceptive door openers. I'm on the internet and I'm watching something, but I don't know it's advertising. I'm engaging with something, but I don't know it's AI based, right? And I might purchase or engage with it because I think it's real. ultimately it's about that misrepresentation. That's where the disclosure becomes more critical. And then with respect to privacy, sort of automated decisions, so like if using AI to just like decide something for a consumer that has sort of like a potential harmful effect, that I think you're seeing the state privacy laws ensure that those models are being disclosed to the consumer in that context. So it's really about whether or not the consumer needs to know with respect to sort of transparency around their product. That's sort of the test, and Ken can sort of supplement on that too, but that's kind of the way that I think about it. It's consistent with sort of advertising disclosures for endorsements. It's consistent with advertising disclosures for native advertising. The rules tend to just sort of apply across sort of the advertising marketing to be different, if that's helpful.
Yeah, and at the risk of poorly paraphrasing VJ here for those on the Zoom, from a consumer perspective, we're looking to Section 5 and making sure that we're being honest and accurate with our advertising. The FTC has referred to deceptive door openers, for instance, as something that's deceptive. But Armin, I was actually wondering, were you referring to disclosure vis-a-vis the Copyright Office as opposed to for consumers? Okay.
Yeah.
What about like Copilot then? Right, like where they're writing code and you're going to register the entire software program, then do you have to disclose your use of Copilot?
And there again, I think the answer is no. I mean, that's a tool for something that you've already created, rather than it creating something for you. And you're using the Magic Eraser as the tool to create the thing. I don't see that as much different than are you using a specialized pen, or is it a specialized paintbrush? I mean, so that's where I think there is a bit of a difference on that disclosure.
Far back. Can you say something about the open source licenses that govern the platform code that people use to build these? And it's a line clearly drawn between innovation on the platform and what's available to the open source community.
So the question has to do with the open source licenses for the platforms. And are we thinking from a copyright perspective, or are you just thinking, what are the issues with the open source?
Well, if you're an AI platform developer, you're going to need to know what the code you're using is governed by and what the implication thing.
And so I'd go really to the license itself from that open source license and what are the terms around it. And just because something says it's open source, there doesn't mean that it's fully open source, and there's different terms specific to that license. And I'd want to look at that and talk to, my licensing council and kind of get their sense on what are the metes and bounds of that license and what we can do and what we can't do.
I agree with that. And I would just add, if you're developing a platform and some component of the source code is open source, but you are selling that platform, you are the Stability AI in that situation. I don't know if there's open source code in Stability AI's, platform, but, the existence of open source is not going to prevent the lawsuit for trademark infringement, for copyright infringement, for those things. So there's a breach issue potentially to Eric's point. And it's not going to be sort of a defense to infringement issues.
And to VJ's point before, disclosure is key. I'm starting to see more and more on some of these some of the AI platforms saying, well, you might get information that looks accurate, but it's not. It could be a mashup of words that says it's a case that's Smith v. Jones said this, but there's no case that Smith v. Jones said that out there in the world, that they've just taken just like you see some of the pictures are a mashup of other pictures that aren't an accurate picture. Just because it spits out information to you that sounds accurate doesn't mean it is accurate. And they're starting to put those disclaimers out there. One more.
I think we need to separate two issues based upon the gentleman's question about open source, right? Where you've got tools, say like Copilot or other tools that basically are generative AI that spit out code that are basically crawling libraries of open source code. And you get into the classic situation where you might have incompatible open source licenses. Some might be, very permissive licenses like BSD, Apache, etc. Others may be very restrictive licenses like, GPL, or worse yet, a Faro GPL. And depending on what you're going to use that open source code, if you're somewhere between LGPL and the very permissive licenses and it's sitting on your servers and there's no distribution, you may be okay. But if you're actually going to be distributing the software code as a mobile app, say, or a downloadable license, you may be in breach of those open source licenses, which may mean you may be facing copyright infringement. So it's fairly nuanced, and I think you have to sort of analyze the use case, and then try to think, you're not going to be able to know necessarily what licenses govern the code that just got spat out.
Helpful, and goes back to my point of, actually look at the terms of the license that we're talking about, and is it something that is a very restrictive open source, or is it a more broad open source? And you won't know, as you said, what was spit out, which license is governing that,
or indeed whether there's a license there at all.
Yeah.
Which goes to the point that I was making earlier. This notion of what are you actually going to use the output for in your business? Where is your appetite for risk on that? And if it's key code and you have no idea about the progeny of it and it might be subject to a license that's going to taint your code base, that's a very risky proposition, as opposed to another scenario where it's not.
To that point, right, like you may be okay because it's sitting in your servers, you're not distributing it, nobody's looking at the code. But now you're in an M&A situation.
Yes.
And your code gets put through Black Duck.
Yeah.
Prove ownership.
Yeah.
Yeah, I mean,
exactly. And that it's so nascent, these issues, and how the use will manifest itself. And so the conservative approach is watch what everybody else is doing, see who's going to get in trouble, and then mitigate that way. But obviously that's not practical. So it goes back to the use case.
Yeah, the use case, and actually read the terms and to the extent you can understand what the output is from those terms.